Well, here we are, finally arrived. Start now to look into the Settle Land Act and to drive the point home. This is the only act that we're ever going to deal with when we're dealing with the right to vest our legal estate. For this is our warranty, and that will become apparent as we go through the act itself. All I'm going to do in this video is I'm just going to read through a few references made through extracts from Blackstone and commentaries derived from a professor in Manitoba, one of the Manitoba universities and such. So I'm just going to read it. I'm not going to get into much commentary. The next video we'll start doing a little bit more commentary and some foundations of what the Settle Land Act is and why it is that warranty that we need in order to finally vest our legal estate, to which then, once done, we don't have any more interest within English law. All right, so I'm just going to read, and of course I'm going to attach this document to the video so you'll have reference. And remember to like, subscribe, share if you haven't done already. And of course, any donation is greatly appreciated. All right, here we go, and I'll begin to read. This is from Blackstone's Commentaries, Laws of England. And it goes on, Blackstone goes on to say, there is nothing which is so generally strikes the imagination and engages the affections of mankind as the right of property, or that sole and despotic dominion which one man claims and exercises over the external things of the world, in total exclusion of the right of any other individual in the universe. And yet there are very few that will give themselves the trouble to consider the original and foundation of this right. Pleased as we are with the possession, we seem afraid to look back to the means by which it was acquired, as if fearful of some defect of our title, or at best we rest satisfied with the decisions of the laws in our favor, without examining the reasons of authority upon which those laws have been built. We think it enough that our title is derived by the grant of the former proprietor, by descent from our ancestors, or by the last will and testament of the dying owner, not caring to reflect that, accurately and strictly speaking, there is no foundation in nature or in natural law why a set of words upon parchment should convey the dominion of land. Why the son should have a right to exclude his fellow creatures from a determinate spot of ground because his father had done so before him, or why the occupier of a particular field or of a jewel, when lying on his deathbed and no longer able to obtain possession, should be entitled to tell the rest of the world which of them should enjoy it after him. These inquiries, it must be owned, would be useless and even troublesome in common life. It is well if the mass of mankind will obey the laws when made, without scrutinize too nicely into the reasons of making them. But when law is to be considered not only as a matter of practice, but also as a rational science, it cannot be improper or useless to examine more deeply the rudiments and grounds of these positive constitutions of society. I love using that as the opening. I mean, doesn't it hit home again? Even all the debates and discussions that I've had with various other people. For instance, and this is true to the fact, I've never lost a debate, nor will you, because now you're using the law. The only problems that you ever have in debate is that they will never discuss the subject matter to the knowledge of through the knowledge of the law. They will always filter through the belief, as you have already seen through past videos with peacekeepers and what was another one? The guy Jay at Robin J or Robin, whatever his name is, and there's been others, and even on Facebook, they don't debate the law. They never do. They debate their belief and then bring that belief into trying to bring some substance or value to what they're saying, according to or measured against what the law has already been determined. This is why I always speak to that the law is perfected. It's always the misinterpretation is through that individual that creates the imperfection in law. And as we have seen, that the law has evolved through issues that arose during the rights to hold land. And again, English law is only about rights to hold land. It deals with land first, it doesn't deal with people, and therefore it makes it perfected in as much as that they're not creating rules over the people, therefore enslaving them or putting them into involuntary servitude. It allows people the free will to make their own choices of what type of property they can hold. So it is us that is not understanding what law is that is creating every issue we deal with in society. To the extent, as it's written in Blackstone's, that we don't care not because it might bring up some fault or some error and we don't want to know about it. We just want to keep on going on our daily affairs and not really comprehending where our rights and so forth have evolved from, or where they are fully secured, and they are secured in each individual. And I just said I wasn't going to do too much commentary, and there I go on and off on a diatribe of useless, well, not useless information, but just started talking for the simple fact of talking. Okay, let's go to the next point. This is says Settled Land Act in 1882, but it was regarded at the time as a little short of revolutionary. Sir Arthur Underhill, writing in 1909 and reminiscing about the evolution of the land law over the previous 100 years, called it this great act, the greatest real property act, I think, of the century. I propose in my third and last article in this series, in the forthcoming volume of the journal, to revive and re-examine the social exigencies which give rise to the debate and its influence on the law's entire conception of what ownership of land means and should mean in the context of limited estate holding. It seems to me that the arguments then in play may be of interest again in light of the new era of real property law, quietly, almost covertly ushered in by Section 4 of the Manitoba Perpetuities and Accumulations Act. And this is taken, and we're going to get into this, this is taken from a commentary that Professor Irvine did on the Chupwork case, whereby, and I'll give you, because we're going into it right away, give you a little bit of segue into it. The reason why what Irvine is discussing in his article, it wasn't corrected in the appeal court case itself because it had no matter to the decision in that appeal. Meaning what the mistake was done within this case, in the Chupwork case, was not a matter for the appeal court to look at because it didn't change the determination on that case at all. So that's why it was never looked at. But in hindsight, it was good that Professor Irvine looked into it. He's from Manitoba University. Why he looked into it was to make sure that if any judge then took this case as absolute and read it as such, he would have made the exact same error, and that would continue to go on ad infinitum, to which now we arrive at the point where when we speak to attorney generals, we have done so in Ontario, Manitoba, and British Columbia, that they still don't see the Settled Land Act. And I think I have some other reasons why they don't see it, but I don't want to get into that, especially in this at this point. But here we go. I'm going to read what had happened so that we get a better comprehension of that that there are two distinct acts. The one that, of course, we want to use from now on, which is Settled Land Act 1925. But inasmuch as that it is the overlying act in the common law that sets precedent for every other estate and interest to now devolve therefrom. So even though Canada or the U.S. or any other, Australia else don't recognize it, but they do have, some of them do have settled land acts. Okay, I'm not going to say they don't, but they don't recognize it because, again, the interest that any of these countries use are the equitable or beneficial use, which is a new agreement. They do not have immediate rights to the Settled Land Act 1925 because that's an individual right, as we say, and it's a common law right, and that is our individual right, to which it doesn't incorporate a perpetuity instrument. Okay, I hope that's kind of clear as mud, but here we go. It's quite permissible to regard at least the first two of these pieces as an analysis or critique of the Manitoba Court of Appeal's well-known judgment in Chupruk versus Heikowski, decided in 1980 and nowadays featured uncritically and apparently without equanimity in leading Canadian texts on real property law. In consequence, Chupruk is likely to have a strong influence on the developing Canadian jurisprudence in various contexts and upon the thinking of law students. It is my conviction that the court's reasoning in the Chupruk is profoundly defective and in some degree based upon a false perception of the law that has promoted me to offer these rather protracted reflections. In this first essay, I consider the Canadian law of settled estates with particular reference to Manitoba, and the judge did not err in a manner that would allow an appeal, yet the loose writing makes an error in law for the Settled Land and Settled Estates Act. So that's Irvine Comp. Okay? But the Settled Land Act was founded upon a broader, and this is another excerpt from, so we're only going to read from the this article of Irvine's. Okay? So each point, like you see right there, page 7 was from, which I read, which was read the first part, but the second part I don't have the page on there. You can go, you've got a link to where you can go to in Canley in order to get this document, and I extract certain things that are read either through the commentary or parts from other people that have discussed commentary, but generally we're going to only speak of the commentary. So it goes on to say, but the Settled Land Act was founded upon a broader policy and has a larger scope. A period of agricultural depression, which showed no sign of abatement, had given rise to a popular outcry against settlements. The problem was how to relieve settled land from the mischief which strict settlements undoubtedly did in some cases produce, without doing away altogether with the power of bringing land into a settlement. That was something very different from the task to which Parliament addressed itself in framing the Settled Estates Act. In those acts, the legislature did not look beyond the interest of the persons entitled under the settlement. In the Settled Land Act, the paramount object of the legislature was the well-being of settled land. The interests of the persons entitled under the settlement are protected by the Act as far as it was possible to protect them. They must be duly considered by the trustees or by the court whenever the trustees or the court may be called upon to act. But it is evident, I think, that the legislature did not intend that the main purpose of the Act should be frustrated by too nice regard for those interests. Okay. He goes on to say, and this is a quote again from Irvine, Manitoba has no Settled Lands Act, and he's taking from the Chupruk case. And present that assertion in such a way as to imply that Manitoba was in some way uniquely disadvantaged by this lacuna in the statute book it is my position in this paper that any such assertions are demonstrably wrong. And he goes on, and here is the Justice O'Sullivan, and this is what he's critiquing. His misinterpretation, where he sort of merges and he sort of overshoots the Settle Land Act, and he sort of merges in with the Settle Lands Act, and thereby that's what creates the error. Okay, but of course there are two distinct, because we've already looked at the Settled Estates Act is for the sales, the grant given to high courts of chancery to administrate over the sales and leases of settled estates under the settlement, so they're dealing with settled estates, and the Settled Land Act is the sales and leases of settled land, two different interests, one common law right and the other a beneficial right. Goes on to say, when O'Sullivan J.A. states in the above quoted passage that Manitoba has no Settled Lands Act, his words are literally true. Manitoba has never had a statute of that name, nor has any other Canadian province, so far as I am aware. The English statutes bearing that title, both the Settled Land Act of 1882 and the Climatic Settled Land Act of 1925, which been the objective or the object of sometimes wistful academic commentary in Canada, but have never been fully adopted or adapted in any Canadian jurisdiction. As Professor Waters put it, the Settled Land Acts of 1882 and 1925 in England never came to Canada. So Manitoba is hardly unique in not having a statute by that name. However, O'Sullivan J.A.'s assertion in the same sentence that Ontario and British Columbia have enacted Settled Land Acts throws some light on what he is really trying to say. So, do his perceptions expressed in the same paragraph as to what a proper Settled Land Act does, what its functions are? It seems that when Justice O'Sullivan refers to the Settled Land Act legislation, he is using expression in a loose or generic sense, rather than as a more meticulously historic or more pedantic commentary might do, or commentator might do. He is, it seems, using the Settled Land Act label to embrace a whole procession of enactments, including not only the statutes which from 1882 onwards bore the name in England, but the procession of more modest enactments which preceded and heralded them and bore the name Settled Estates Acts. If that is indeed Justice O'Sullivan's position, that for practical purpose, the English legislation can be regarded as an unevenly paced but consistent progression, gradually extending the powers of disposal affecting settled land. It is a perfectly coherent and tenable perspective upon the law. But if, taking this inclusive view of what Settled Land Act means, he still says that Manitoba has none, he is simply wrong, as I shall show presently. A different but less disturbing criticism that might be leveled at this analysis is simply that in its lumping together of Settled States Acts and Settled Land Acts, it conceals more than it reveals. For purists, and that's what we are, guys, as they might term themselves, would certainly insist that despite their superficial similarities of name and function, there is a gulf between them in terms of the social and political theory which underlies them. This is not the place to examine the political struggle which attended the introduction of the first Settled Land Act in 1882, but it was regarded at the time of a little short of revolutionary. And I'm sort of just going to repeat because I took this extract and we read it already first, but it serves to continue reading it. As Sir Arthur Underhill, writing in 1909 and reminiscing about the evolution of the land law over the previous 100 years, called it the Great Act, the greatest real property act, I think, of the century. Proposed in my third and last article in this series, in the forthcoming volume of the journal, to revive and re-examine the social exigencies which give rise to the debate. and its influence on law's entire conception of what ownership of land means and should mean in the context of limited estate holding. So this whole commentary, if you now have a link towards it, is a great read if you want to get some more, a better assimilation of the power that you have when you use the proper act, and also to know that when you're listening to the justice, when you're getting your legal estate vested, you can hear certain things that the justice is going to say that he'll be talking about the settled or the beneficial interest, and it's up to us to pull them out of that and not to commingle, because we are only interested, just like when we go to court and we try to bring in other matters and they go, they're not hearing you. Well, the same thing applies. We are the court, we bring in the law, and that judge is only to listen to us according to what we're bringing in. If he decides to think that he's going to bring in something else, hey, so sad, too bad. You are not going to do that, because we're only going to speak to one act, and that's a Settled Land Act, and we're not speaking about the beneficial interest. We're only speaking to the legal estate. And with that, I'll end this, and now we're going to get into the foundations of the Settled Land Act 1882. And again, remember to like and subscribe and share, and now that you've got this kind of sort of information, a bit of depth to it, you can now walk a little taller with the fact that if anybody comes, any lawyer, it doesn't matter who it is now, government, agency, whoever, you know what act you're standing upon, and that those who are trying to exercise any force can only exercise those force to the agreements that they've made, but never do they have a right to that common law interest that you as an individual has.